And we are live on YouTube, and I'm going to let everybody in. Good evening, everyone. If you're just joining us, this is the Renters Alliance Renter Town Hall. We'll get started in just a few minutes. Thanks for joining us.
Can you open the chat, Matt?
Yeah, let's do that. Everybody just joining us. We'll get started in just a minute. Renters Alliance Renter Town Hall. And we'll give it one more minute. Okay. If you're just joining us, this is Matt Losack. I'm co-founder and executive director of the Montgomery County Renters Alliance. This is the Renters Alliance Renter Town Hall. A couple of things. If you have any questions or concerns, we ask that you put them in the chat. We'll get to them as we go. Our moderator this evening will be Emily Towie, our outreach coordinator. And we have some special guests. We're going to start with our elected officials who are here with us tonight. Right now, we have Delegate Lori Charkoudian, but we're also expecting Delegate Janelle Wilkins and Delegate Mary Lehman. And then afterwards, we'll have Attorney Zephyr Shaw from the Maryland Legal Aid Bureau, who will also be, there's Janelle, and who will also be joining us, who is with us, who is going to give us an overview of all of the legislation and perhaps provide some more detailed information on the legislation not discussed by the delegates. Zephyr and I were co-founders of Renters United Maryland. And we are deeply appreciative of Renters United Maryland for their coordination of outreach and targeting of the legislative session so that renters have a voice in making sure we're protected against legislation that is going to be harmful to us and that we advance legislation that is of service to advancing renters' rights in the state of Maryland. I, on the other hand, have to go off to another activity, so I'm going to leave it to Emily Towie, our outreach coordinator, to introduce our staff and our delegates and to continue with this town hall. So good evening, everyone, and welcome. Emily, it's all yours.
Thank you, Matt. As Matt said, my name is Emily Towie. I'm an outreach coordinator. I will be moderating tonight. Want to introduce our staff here with us. We have Pat Beckham. We have Waho, who's with our the Governor Wes Moore's Service Year program, and we have Tim Wong, another outreach coordinator like myself, and David Mullins, our senior analyst. I want to start by introducing our special guests. We have a lot of special guests tonight. I'm going to start with Delegate Janelle Wilkins, who is a champion for good cause legislation among lots of other renter protections. Thank you so much for being here, Delegate. Feel free to tell us a little bit about yourself and then jump into how the session went and any bills you want to highlight for us.
Hi, everyone. Good evening. It's always wonderful to be here with my Renters Alliance family and with renters across the county. I am Delegate Janelle Wilkins. I've served in the legislature since 2017. When I came into the legislature, I was a renter, and I also served on the board of the Renters Alliance. And so this issue is one that is very important to me. Not only are we working to make sure we push legislation that protects renters and makes housing more affordable and your homes healthy and safer. We also want to make sure that we are pushing back during the session on harmful bills that could expedite things like evictions or end up putting more burdens on renters. So I, as you probably know, have championed the issue of good cause eviction, that legislation. This was the ninth year that I introduced it. This session, I also introduced a new bill that I want to talk about as well. And that bill is called the Safe and Healthy Homes Act. That legislation looks at our properties that are just constantly having issues when it comes to health and safety. I'm talking mold, issues dealing with the doors not working, cameras not working, things that deal with bed bugs, just the really terrible locations that are uninhabitable. And no one should be living in those types of conditions, especially when, as a renter, there is almost little usually that you can do in those situations. For another example is rodents that are all over the building and that has not been addressed. So those egregious properties, I would introduce legislation that would make sure the state would step in. We know that Montgomery County comes in, they issue citations, they of course inspect, but for those properties that really are at that high level of really SOS in terms of health and safety violations, we need interventions. So my legislation requires Department of Housing and Community Development, which is the state agency, to work with the Attorney General to step in and identify hard-hitting solutions. That could be a lawsuit that the Attorney General can file on behalf of the state for that landlord. That could be heavier fines, and really working until that property is brought up to code and those renters have a safe and stable and healthy place to live. And so that bill did pass. It was a priority bill of the Legislative Black Caucus of Maryland. And I want to thank Delegate Charkoudian, whose committee, which is the Economic Matters Committee, deals with legislation that has housing as a topic, and she championed and helped support this bill in committee, and it passed the Senate as well, and we got that done. So I want to start off with good news for renters that with this legislation, we're on our way to ensuring that the state will be stepping in order to provide some mitigations for housing. The next bill is the good cause eviction legislation that I've introduced. This was the ninth year. And I have good news and I have bad news. The good news is that we were able to get that bill through the House once again. This is the second year that the bill passed the House. And I think it's important that those wins of getting it through a chamber, that we celebrate that and we thank our supporters and our champions, like again, Delegate Lori Charkoudian, who not only helped get it through her committee, but also led the bill on behalf of her committee on the floor through hours of debate and pushback and amendments and all kinds of efforts to weaken the bill by Republicans. So it was not an easy feat getting it through the House, and we should absolutely celebrate that win. Unfortunately, the bill did not move in the Senate once again. And I want to point out that in the Senate, the bill was introduced in February. So there was plenty of time to move the bill, to come to the table and make sure that it passes. So unfortunately, we did end up in the situation again where the bill passed the House and the Senate did not take action. I want to answer a question quickly from Ronald, who asked about, because I'm on the topic, how do we get Senator Smith to move the bill? I think that the ask, especially if you live in Montgomery County or live in District 20, is for the senator to come to the table and identify and work with residents around a workable solution that he believes will pass the Senate, something that does not weaken the bill, and get it in that form by the time we start session January 2027. So I think the ask of him is that we have 9 months till the next session, and that he work with me, the bill sponsor, and also renters and advocates across the state and Montgomery County to get it into a form that we can get moved very early in session next year. The last thing that I'll say is I want to thank Zephyr Shaw, who's been a part of this movement for a good cause since the very, very beginning. back when it was a local bill. Now it's a statewide bill with support all across the state. We had the mayor of Baltimore's team testifying. We had a resolution from Baltimore City. We had support from the Prince George's County delegation. We have all types of organizations working towards good cause. This is a bill that has the momentum and the support. We just need action in the Senate. So I will end on that note and thank Matt Losack for his work and his leadership on good cause and also with renters all across Montgomery County. Thank you so much for having me on.
Thank you so much, Delegate Wilkins, for that breakdown. And again, thank you for sponsoring the bill, and to Delegate Charkoudian for leading the charge on the floor debate. Of course, we are disappointed that it didn't pass this year, but like the delegate said, we do have to even acknowledge that it did pass the House with great numbers, which shows that people want to see this passed in Maryland. And again, this is a local enabling bill, meaning that it gives local jurisdictions the choice to implement. It's not automatic that all counties will be subject to good cause. It only just gives them the choice, which right now, the Montgomery County does not have the choice. The Montgomery County Council couldn't implement this even if they wanted to. Um, and just in our experience, we work with renters all the time who face retaliation. And there's just little or no defense to that because the landlord doesn't have to provide a reason why they're not renewing you. And that allows for a lot of loopholes for getting out tenants who are just asking for the services that they are entitled to. So we are hopeful that it does well next year. And thank you so much, Delegate Wilkins. We will definitely have you back on and hoping for the best for next year. And thank you for all the work on the other bills that we're able to successfully get through. And feel free to stick around, but I'm sure you're very busy. Thank you so much for being here with us. Any questions for the delegate before we let her go? We're seeing anything in the chat? Okay, not seeing any questions right now. I'm going to turn it over to Delegate Charkoudian.
Great. Well, thank you. Good evening, everyone. I'm Delegate Lorig Charkoudian, and I am a district mate with Delegate Wilkins, and so honored and excited and just have so much respect for her and the work that she's done on renters issues, and then in particular coming back year after year on this issue of good cause. Like, I trust that it is going to get done because of her perseverance and because of all of your perseverance. And I'm happy to be part of it now. I'm the vice chair of the Economic Matters Committee, and so we now have many of the housing bills, most of the housing bills come to us. Unless there's some sort of weird thing like one of my bills, which is related to water utilities. So I'm going to talk about two of the bills that I brought this year that did pass. So the first one was brought to my attention by the Renters Alliance, and it was related to I think the Grand Apartments in Bethesda, Rockville. There was water sub-metering that was put into place. And so, similar to electrical sub-metering, it allows a landlord to charge each unit for the amount that they actually use. And so there's benefits to that if it's run properly, because you're charged for what you use, and if you choose to conserve, then you can benefit for that. But the problem is if landlords take advantage of it or charge outrageous fees, it can create a really significant consumer protection issue. And so in the situation that was happening at the Grand, a couple things happened. One is that the landlords were charging exorbitant administrative fees just to be able to have the sub-meter, even though the tenants didn't have any choice in whether they had it or not. And so it was really a way to get around rent stabilization by charging this fee every month. And then the second thing that happened is that the sub-meters were broken, and then they were using estimates based on usage from the middle of the summer, and they use those estimates for several months, long after it was likely that the tenants were still using the same amount that one might use in the middle of the summer when you're likely to be using more water. And so Renters Alliance brought the issue to my attention. I met with folks at the Grand, and met with consumer protection folks in Montgomery County, and we put together a bill that what we found was originally we were trying to figure out who regulates this, and we found that no one does. And so we didn't have any laws related to water submetering. And so basically what we did is we put into law a structure that mirrors very closely the electrical submetering structure, which limits the administrative fee to $1 a month, and then also has a number of things in place in terms of transparency, in terms of the need to address water leaks, address fixing the meters when they're broken, and how long you have to fix them, and how long you're allowed to use an estimate. So we hope that that goes a long way to create more consumer protections around water utilities. The second thing that I worked on, folks might be, well, I'm sure everyone here is familiar with the Arrive Fire, where we tragically lost Melanie Diaz and many people were displaced, and there continue to be challenges at Arrive. But at that point, I started working on understanding what was going on with fire safety and a lot of the high-rise buildings in Montgomery County that don't have sprinklers. And sprinklers are, of course, the best way to keep a high-rise building safe, but there are other fire safety tools that high-rise buildings can have in place. If the buildings were built before 1974, most of them don't have sprinklers. And so over the last few years, I've been bringing in bills that are related to fire safety in high-rise buildings. And so my bill this year did two things. The first thing that it did is it required that if there is a major renovation that occurs in a building, up to 40% of the value of the building, then sprinklers have to be put in. You do have some situations where it seems like significant investment is being made in the building, but because there's not a sprinkler requirement, because they're grandfathered, if they were before 1974, then other investments are made, but these really important safety investments aren't made. So that's one piece of the bill. But the other piece of the bill that's really important is related to the qualifications of the fire inspectors. And so in this sort of perverse way, what we found out is that the buildings that are sprinklered get inspected by contractors who have a very specific license for sprinklers and other fire safety equipment. But the buildings that aren't sprinklered don't have licensing for the people who do, the contractors who do those inspections, maintenance, and testing. And so what you end up with is the buildings that are already safer are getting better inspections and maintenance and testing, and the buildings that are not as safe are getting the, not certified or not licensed inspections. And so what my bill does is it adds requirements to the folks who are doing the inspections in the buildings, the fire safety inspections in the buildings that don't have sprinklers, to make sure that all of those other life safety equipment is tested, maintained, and up to par and at its maximum effort to be able to save lives in the event of a fire. And so I'm happy to say that that bill also passed. And so those are the two bills that I sponsored, and happy to take questions on any of them.
Thank you, Delegate, and so happy to hear, to have something to celebrate that two very important bills were passed. Of course, we were happy to testify for House Bill 220 on the water billing, and thank you to Zephyr for all the work he did on that as well. I know it's really important to tenants to have as much transparency as possible when you're dealing with complicated utility bills that you don't know how they're being calculated. They seem like they should be more than your usage. So I think that this bill is really important for bringing transparency to renters. And like you said, it's just basically making it parallel with the rules for electric billing. So really happy to see that that has passed. Are there any questions for Delegate Charkoudian? And also, Tim put all the bills into the chat. If you want to read more about them, check out the links in the chat. Last call for any questions for our delegates or any comments? Not seeing any. Well, thank you guys both so much for your leadership, for sponsoring these important bills. Very happy to have two friends in D20, two renter allies in D20. Thank you so much both for being here tonight. I'm not seeing any questions, so I will let you guys get back to your evenings. Of course, you are welcome to stay and hear the overview that Zephyr is about to provide us. If not, we will definitely be asking you guys to come back on again, and we will be supporting you next session, hopefully to get some more bills across the finish line. Thank you both so much. Okay, well, let's turn it over to our next special guest, Zephyr Shaw with Maryland Legal Aid.
Yeah, thank
Zephyr, if you
you.
want to introduce yourself and
Sure.
thank you.
All right. Thank you, Emily. And very, very happy, proud to be on a panel with these outstanding leaders from the General Assembly. Worked really hard. And, you know, when we are in session as advocates, I mean, all of us always wonder how you all do it for 90 straight days. It's incredible. And of course, it only gets harder the longer you go into session to the last week. So my name is Zephyr Shaw. I'm the Advocacy Director for the Human Right to Housing subject area at Maryland Legal Aid. As many of you know, Maryland Legal Aid is a statewide nonprofit law firm. We serve the lowest income, most vulnerable populations in Maryland with their civil legal problems, including housing instability, such as substandard housing conditions and eviction. And we're very happy to be partners with Montgomery County Renters Alliance. We're both grantees of the Access to Counsel and Evictions program. And it's been great to continue our relationship, whether it's at Rockville District Court or in Annapolis. I'm going to share my screen now and go over kind of the whole range of legislation that involved renters' rights, both the wins and the losses. So Emily, just give me a thumbs up if you can see my screen. Okay, great. So we're going to talk about these categories: evictions, tenant screening, which is very related to fair housing. So I put these in one category. Housing conditions and leasing practices. I might skip housing preservation out of just time constraints, but then also touch on this issue of criminalization in the housing arena, which has just become a unfortunately hot issue. So let's start off with just the picture of the good, the bad, and what will have to come next in the future. So really top line is the amazing outcome with the budget. Budget advocacy was successful in a session where, you know, back at the end of December, advocates were being told, don't bother asking for money for eviction prevention funds in the Community Schools Rental Assistance Program. There were about $31 million in rental assistance applications requested between October and December of last year. That was the standing up phase of the Community Schools Rental Assistance Program. Community schools are schools designated by the state. This is part of the blueprint for Maryland's future, the education policy. These schools have resources for parents and students. So $5 million was the line item. This is what was put into the program in years prior, the year prior. So what the outcome here is that not only did the legislature put more money into the Community Schools Rental Assistance Program, they more than doubled the amount. So there is actually going to be $11 million in this fund. There is an additional $1 to $2 million that will be generated from the surcharge on failure to pay rent eviction filings. That was part of the governor's agenda 2 years ago. So that brings you up to about $12 to $13 million. Nowhere near the need. Okay, let's be very real about that. However, this is an outstanding outcome in a year when we're still facing a big budget crisis, when a lot of programs are not being funded, and when some programs that are very important were actually reduced in funding. So there will be more details forthcoming about how these funds will be used in terms of like when does the next round kick off. You know, if you're not a fan, like a household that has students enrolled in school or school age kids. This may not seem important, but it is a very valuable supplement in the overall housing stability picture. The next big headline here is the Fair Chance in Housing Act. This is a monumental bill. This is the first time across the state that we're going to have tenant screening restrictions, and it targets tenant screening based on criminal background. Montgomery County has a law on this. So does Prince George's County. This law is stronger. And because it's stronger, it will actually preempt and supersede the local law. I'll go into the details in a moment. In a similar vein, legislation was passed. This is House Bill 315, Senate Bill 335. There's another great Montgomery County connection here because this was Delegate Vaughn Stewart and Senator Sarah Love at the helm of these cross-filed bills. So what this bill does is it, in the vernacular here, it closes the source of income discrimination loophole where people with vouchers have, despite the legislation passed in 2020 to stop source of income discrimination against people who have vouchers, there has continued to be the use of income testing, like multipliers of rent in the screening process, credit score checking, adverse credit history checking to deny voucher holders, even though they have at times all of their rent promised to be paid by by DHCD and its counterparts. So we'll get into some of the details about that, but this is huge to close that loophole. Air conditioning requirements will become standard across the state starting June 1st. Of course, Montgomery County already has a good air conditioning law, which stands to get better with new legislation introduced in the county council in March. Interestingly, right around that time is when language was added to SB 12 to preempt local air conditioning requirements. That language was defeated. If you're interested in mobile homes in Montgomery County, the SB 729 will really be important. It's extending our access to counsel and evictions law to cover not just renters and mobile homes, but the mobile home owners who rent the ground at the mobile home park. So they face losing at the time of eviction, they could lose their entire asset. A mobile home is valued at somewhere upwards of $80,000 or $90,000 or more. They could lose that because it's so difficult to move their mobile home at the time of eviction. So SB 729 was a comprehensive mobile home resident protection bill. The only piece of it out of 38 pages that passed in this session was the piece about providing attorney representation in those eviction cases for mobile home residents. So it's round one, and in the first year, you often don't see a bill succeed as much as this one did. The Disparate Impact Fair Housing Bill, HB 573. This is a bill that basically codifies the federal law and HUD and DOJ guidance on disparate impact fair housing. And what that disparate impact means is when you have laws that are facially neutral, there's no intent behind the law or no intent by an actor to discriminate unlawfully, but the effect of that policy or those actions actually has a discernible sort of statistical impact on a certain protected population. So this basically puts into state law what is at risk that we risk losing under the Trump administration, which is that disparate impact theory, that discriminatory effect theory of fair housing law. So that's a success. The next bill, debt collection licensing exemption for property management, was a wish list for AOBA and other lobbyists for the multifamily real estate industry. That bill, thanks really specifically to the vice chair of the Economic Matters Committee, Delegate Charkoudian. This bill was stuffed in the House. It did get out of the Senate, So there was traction on this issue. But debt collection licensing is it is, I should say, is not one of, it is the only state regulation of property management. And it's specific to their activities when they're trying to collect money, whether through letters or at the property or at court especially. So this was an important one that advocates rallied to defeat. The bad. Okay, so Delegate Wilkins did mention a good cause eviction, although it crossed from the House to the Senate for the second time in 9 years. It again died in the Senate. I saw one of the questions in the chat, which was, what are you doing to bring down the cost of rent? This bill, ineluctably and unfortunately, was part of the debate on rent stabilization in Montgomery County. And the reason, probably the primary reason that this bill has not passed for the past 3 sessions is because the multifamily industry is trying to use this bill to make Montgomery County's rent stabilization law weaker so that rents can go higher. And the success here is not just that it passed the House, but that we did not allow that weakening to happen. So the amendments to try and preempt Montgomery County and Prince George's counties rent stabilization laws did not fly. That was not the outcome here. And unfortunately, it meant not passing good cause eviction. This bill would enable counties like Montgomery County to pass good cause eviction at the local level. And that just remains another goal for the future. Another bad bill that did pass is SB 82. This bill criminalizes the possession of a counterfeit lease. Now that might sound like not an issue for many people, but what this ties into is the scourge of rental scams that are affecting particularly low-income renters in Maryland and probably across the United States. People are responding to ads on Facebook Marketplace and what have you. They do not know that they're in possession of a fraudulent counterfeit lease until some other actor alerts them and says, hey, I'm suing you in district court to get you out of the property because you have no right to be there. If a tenant is waiting for their day in court, well, now they are holding what's alleged to be a counterfeit lease, and there's, potentially you could construe this as intent to have the counterfeit lease in their possession while they await their court date. This now subjects tenants, or I guess putative tenants, like people who think they're an actual tenant, to being charged criminally with a misdemeanor crime. Unfortunate. The future, we'll get into some of this, but House Bill 313 did not succeed. It passed the House and died in JPR in the Senate, Judicial Proceedings Committee. This would have prevented the use of eviction history, or I should say limit the use of eviction history in tenant screening. HB 1456 was a bill that would have actually prevented rental scams by holding websites or the companies that publish these ads for rental properties or even for sale properties, for them to verify the ownership through, basically vetting the person that is posting the published ad. There will be a couple interim actions. So Delegate Wilkins mentioned the bill HB 1218, which creates with DHCD and the Office of the Attorney General the Safe Housing Intervention Plan. This is going to get off the ground July 1. This is an opportunity for organizations like Montgomery County Renters Alliance to get into the conversation with these state agencies to talk about where resources need to be put together, what are the problems that need to be targeted. So look forward to that. SB 180, fair housing testing. I shouldn't have this on here. This bill was supposed to become, let me back up. This bill passed the Senate. It's passed the Senate multiple times. It is meant to provide fair housing testing organizations the ability to record when they're doing sort of like secret shopper testing at properties for fair housing purposes. They're not allowed to do that, and this law would have let them do that. It became in the House amended so that it's just a study on one-party consent in general, and then it still didn't pass. So we actually don't know what the future is for this bill. It's clearly a needed bill. It clearly has traction in at least one one chamber, but it just hasn't got over the finish line. For things like fair chance in housing, voucher holder discrimination, other forms of discrimination, you really have to have fair housing testing stronger than what we have in the state of Maryland. HB 810, blockchain deeds and leases. This sounds a little obscure, but it could be one of these things that really comes out to change the game as far as this criminalization issue and the so-called squatting issue. So this is going to be a study in which State Department of Assessments and Taxation will be working with an enumerated list of different stakeholders, including Maryland Legal Aid and Public Justice Center, to think about how blockchain technology can be used for the verification and authenticity of deeds for property, as well as leases for renters. So we were effectively able to get leases added to this study. It wasn't part of the conversation, but we know that verified leases are important to low income and all renters. So I'm going to go, this will be sort of like rapid fire. And Emily, please just tell me for a minute how much time I have left for this.
You're good.
I'm good.
Yeah, go ahead.
Okay.
Yeah, you're
Great.
totally fine on time.
Okay.
We can do there's some questions in the chat, but we can hold those till after you get through.
Yeah. Okay. I'll try not to repeat myself or anything here, but just for the legend of this document, basically this cricket player is the bills that are on the offensive. They're like supposed to support renters' rights. The brick wall is the defensive actions we took. The green W is a desired outcome achieved, and the L here is an undesired outcome. So we've talked about community schools rental assistance, the mobile homes ACE expansion, good cause eviction. Anne Arundel County had a bill, so the delegation had a bill focused on creating a more definite timeline for failure to pay rent trials. They're probably one of the fastest jurisdictions, so this may not seem relevant to Montgomery County, obviously, but it is an effort that could be interesting to advocates in Montgomery County, where the trial date would be set 13 days out from filing and the summons posted at least 7 days before trial. The posting of the summons, as some of you might know, could happen at any time, and often it doesn't happen with enough time for a tenant to actually call for legal services, get representation, or even talk to their property management before the trial date. So there are a couple defensive issues here with this whole squatter narrative. There are attempts to speed up court processes to quote unquote get squatters out. This has already been done in the 2025 session when they already created a 10-day timeline for trial, a 10 business day timeline for these actions. HB 59 wanted to speed it up to 5 days if the property is alleged to be currently for sale. HB 858 was an attempt to just shrink 10 business days to 14 calendar days. That did not succeed. There was a bill on allowing plaintiffs, like owners in these cases, to not have to show a deed, but show some other document that would corroborate that they're the owner. That bill did not succeed. Tenant screening. We talked about fair chance, and I want to go into some of the detail here about what the fair chance bill does. So like, as I said, this is a major milestone for tenants in the state of Maryland. Whether you have a criminal history or not, this really sets a template for what is fair in tenant screening. So there are over 1 million people in the state of Maryland that do have criminal background. So really the impact here is massive. Let's just get into some of the details. I don't want to get too far into the weeds of how screening will happen October 1st of this year and going forward. But basically, the bill restricts the use of conviction history. It's really focused on convictions. Things like arrests and charges that were dropped, misdemeanors, these are flat out no longer on the table for tenant screening. What can the landlord look at then? Of course, they can look at your consumer history. They can look at your eviction history. They can look at your credit score. They can ask for references from your prior landlords. All that is fine, but for criminal history, they can only look at 6 convictions. Okay, like the real big, we call them the big 6: murder, human trafficking, child pornography, sexual assault. The sexual assault category is very broad. It really covers just about everything under that part of the criminal code. Being on a sex offender registry or being required to be on a sex offender registry. These are all in the big 6. So this means that landlords can use information going back any amount of time. So if it's a 20-year-old conviction, for instance, they can look at that. Is it a 20-year-old offense? It didn't lead to a conviction, then it's off the table. Again, it has to be a conviction. After that screening, if a tenant is still a viable candidate, the landlord makes what's called a conditional offer. So it's an offer to reside at the property, but it's an offer which can be withdrawn if the landlord finds something in the next round of criminal history screening. And so that criminal screening that happens after the conditional offer is limited to the 5 years before the application, and it is any felony conviction in that time. 5 years from conviction up to the application. Not 5 years from release. It's not 5 years after you get out, you can finally get a fair chance at housing. It's 5 years after conviction. And it's for all felonies. If you have an out-of-state felony, it counts here if, for instance, the elements from the other state are similar, basically similar to Maryland's criminal elements for the felony here. All right, so let's say that the applicant did have a felony conviction in the past 5 years, and the landlord wants to withdraw the conditional offer and say, I'm sorry, you're denied. The landlord can only do that if they meet a substantial, legitimate, non-discriminatory reason. Okay, that's a mouthful. Substantial, legitimate, non-discriminatory. This comes straight out of fair housing law at the federal level. And so what it means is if, for instance, there was a assault conviction within the past 5 years, the denial now, the withdrawal of a conditional offer, needs to be something, there needs to be a reason for this withdrawal that is substantial, legitimate, and non-discriminatory. Not or non-discriminatory, it's all 3 of these things. So it is quite a standard. There will be a form that Department of Housing and Community Development at the state level will create for basically standardizing these notices of withdrawal of the conditional offer, the language that needs to be there, the rationale that needs to be stated, the specific information about the withdrawal needs to be stated in this notice. That notice will also state, for instance, that the applicant has 30 days to request all of the information that was used by the landlord to withdraw the conditional offer. And once that request is received, the landlord has 10 days to provide that information. And this is important because the next part of the bill, this legislation, is what we call the individualized assessment or reassessment. So the applicant with this information can now see what was used and they can rebut it. They can provide mitigating factor information. It has to be written evidence under penalty of perjury. It is stuff like, I was only 20 years old. Okay, I made a mistake. It can be I rehabilitated. I have letters from people who say that I'm actually quite a great person to live next to these days. The landlord will take this information and they have to do a 6-factor reassessment. So things like the age of the person, did the conviction involve rental property, for instance? That there are 6 factors that need to be taken into account. All right, so this is the ultimate question with this bill is, okay, you just listed all these things that property managers and owners have to do It's fairly complicated. It's not exactly business friendly. So what happens when landlords just break this law, like left and right? And this is where, in negotiation back and forth, some strong parts of the bill did fall out of the equation. And so when we talk about enforcement, this is really the future of this bill. There is no part of the bill that says the tenant will be able to sue the landlord for X amount of damages or what have you for every violation. It doesn't say that. It does not have a section that says the Office of Attorney General will enforce this law this way. It doesn't say that. But what there is, it in some ways, in terms of like what it doesn't say, this bill still allows, by the absence of language, that tenants will be able to sue under other grounds. So, for instance, a allegation that violation of this law was an unfair trade practice, and they can sue under the Consumer Protection Act. They can file a complaint with the Office of Attorney General Consumer Protection Division, which is way easier than filing a lawsuit. That's just a complaint online, and it goes into investigation very quickly at the Consumer Protection Division. Because there are civil rights and fair housing issues kind of wrapped up into this whole process, it's feasible that a tenant could file a complaint with the Maryland Commission on Civil Rights. The one thing that's very specific in this bill is that whenever there is an opportunity for a court to enter a civil penalty against a landlord who violated this law, that civil penalty is capped at $500 per violation. So that's really the only specific thing in that bill. Okay, I said I wasn't going to take a deep dive. I hope that was sort of like almost a deep dive. It was in the middle of the pool. So I'll go a little more quickly on closing the source of income discrimination loophole. This bill I described, and I just want to tell you how, like, what if you're a voucher holder to expect in the new tenant screening that becomes effective October 1st. So really think about income tests, like these ratio of income to rent tests, credit scores, and credit history. And these things are being restricted. They're not being completely made unlawful. So with adverse, what can a landlord do? They can use adverse credit history from the time before the voucher holder had their voucher. There can be ratio testing of income just to check if there's income sufficient to cover the portion of rent not covered by the voucher. And then there are things like using landlord references and using history of lease violations, including the failure of the tenant to have paid utilities in the past. That can be used, but only in a reasonable way, a commercially reasonable way that's non-discriminatory. And so the non-discriminatory part of this, whether it's for ratio testing or landlord references, etc., basically the meaning here is that if voucher holders are being scrutinized this way, the landlord better be scrutinizing everybody that way. Otherwise, it's discriminatory in violation of this source of income law. I told you about House Bill 313 and disparate impact.
Sorry, Zephyr. I had a
Yeah.
question about the one
Sure.
you just discussed.
Yeah.
So about the ratio, so like what we often see is like your income has to be 3 times the monthly rent. So with this new bill, like starting October 1st, if I'm a HOC voucher holder, and my voucher covers $1,000 and I'm responsible for 500, are you saying that they can still have like the 3 times requirement, but based off my portion, not HOC's
Yes.
portion? Okay,
That's right.
great. That's
That's right.
great.
That's
That's really
exactly-
great to hear.
Very well put.
I know a lot of our tenants, they're like my voucher covers almost everything, but they're still expecting my income to be 3 times, and usually if your income is that high, you wouldn't be able to qualify for a voucher. So, really, really glad to hear that it will starting October 1st, that will be the case. Thank you. Continue.
Mhm. Okay, so we talked about air conditioning, we talked about severe health and safety risk property intervention plan and the water submeter requirements bill. There's a water quality testing bill. This is really specific to well water systems at mobile home parks. So there will be an action plan for enforcement standards of well water. Lead risk in housing. The historic Maryland law from 1996, which is why there are lead inspection certificates at change of occupancy for many properties. This was expanded to cover rooming houses where a tenant is not renting out a full rental dwelling unit with all the accommodations, just a room in a house. So if you think about a 3-story townhouse and each room is its own tenant, but everyone shares the kitchen and common areas. That's a rooming house. Those are now expressly covered under the reduction of lead risk in housing law, which means that if it was built before 1978 and it's not lead free, there has to be a lead risk inspection done at change of occupancy. For folks who are 60 or older, the Office of Home Energy Program will now have their redetermination process expanded to cover you. It was at 65 plus, it's now 60 plus. This redetermination means that a person who has used an energy assistance program will not have to reapply annually. Instead, the state agency will send a letter simply asking that person to confirm that they've not had a change in their eligibility status. So this is a kind of policy that just makes sure that more people who are eligible are actually using the program. And it's been tangibly effective. It will be more effective with the age 60 threshold. So that starts July 1st, 2026. Delegate Vogel brought the fee disclosure bill back for a second year. This bill would require that leases for landlords of 5 or more units, that in their written lease, they describe all of the mandatory and optional fees that would be charged to a tenant under the lease. What it doesn't cover is utilities, including garbage collection, as well as fines and penalty fees. This bill passed the House. It did not get a vote in the Senate and JPR, and Judicial Proceedings Committee. HB 1456 we talked about was the rental scam bill. That did not get a vote in the Senate. We talked about the debt collection license exemption, but there was a late file bill, House Bill 1644, which is a more comprehensive licensing scheme for property management companies across the state. So when it's late filed, it goes to the Rules Committee, and the Rules Committee would have to vote to let it out of the Rules Committee to send it to the appropriate committee, like Economic Matters. That did not happen. This bill is sponsored by Delegate Terry Hill, and it could be something that Delegate Hill brings back. It is, like I said, there is not a statewide licensing or any kind of like regulation scheme for property management. I think a lot of our clients, I'm sure a lot of you have a sense that property managers just get away with everything. This would be an effort potentially in the future to rein that in. 2 other bills in the leasing section here. So these are similar bills. One was House Bill 434 brought by Delegate Plakovich Carr to prohibit the use of AI price fixing software or price coordination software. This was in the news last year. This bill came back for a second year and still did not get a committee vote. But basically the problem is where there's software out there, principally the software used by RealPage, which allows landlords at one property to see the prices being set or the prices that could be set based on other software users, and then also to set their occupancy level so they can actually take property or units out of the marketplace based on this data, as well as set certain lease terms based on this data. And the allegation has been that this is collusion and violation of antitrust laws. And this bill would be an express way of preventing that. HB 1475 similarly would prohibit the use of algorithmic softwares to set these terms. It also would require retailers to conspicuously disclose dynamic pricing. So like at the grocery store, or the corner shop, wherever. None of these bills got a vote in the House, which is unfortunate. So I'm going to skip housing preservation really quick. Might come back to it if we have time. So let's talk about the criminalization. We talked about SB 82 counterfeit leases. The bill, the task force to study deed fraud. So this is another task force on this issue of squatting. Basically, the importance here is that there is a study report that will be published to the General Assembly before July 1st, 2028. So what this does is there's no immediate problem. It's just that in 2029, there will be another round of this kind of angst and concern about squatting because it's going to be based on this task force study. As far as I know, there are not really like advocates for low-income people or renters or anyone who's at risk of actually being defrauded in the rental scam area that are going to be a participant in this study. So hard to know what the value of it will be. Okay, so two issues around criminalization of homeless persons. These are actually both good bills, not bad bills. So the cricket player here. So House Bill 104, SB 49 was a second effort after last year's initial effort to address the Supreme Court case Grants Pass from 2024. And basically, this bill would say that people who do not have a home maintain the right under the Maryland Declaration of Rights to conduct life-sustaining activities. And if they were arrested for doing those life-sustaining activities in the public right-of-way, they would have a defense. And life-sustaining activities are things such as sleeping, sitting, etc. It does not mean that people can commit crimes such as disturbing the peace and other things. It's really about a specific list of life-sustaining activities. That bill did not get a committee vote. There was a similar bill on this topic, which is House Bill 432, Senate Bill 463, to prohibit local statutes from including vagrancy as a crime. So really, all the bill does is strike the word vagrancy from what municipalities are allowed to do at the local level. This passed in the House. In the Senate, it actually got out of judicial proceedings and was amended on the Senate floor just to clarify that local law enforcement can still enforce laws against disturbing the peace, for disorderly conduct, etc. But then it was special ordered, which is like a maneuver on the floor. Usually bills come back from being special ordered. In this instance, it just never came back. So it was on second reader. It never got to third reader in the Senate, and then did not cross over to the House. I'll briefly mention this one bill, SB 938, because it is an interesting idea that we should all think about. So this was brought forward by the Maryland Affordable Housing Coalition, which is a coalition of basically nonprofit developers and management companies that manage like tax credit properties and other affordable housing properties. And what they wanted was that there should be $5 million in the Department of Housing and Community Development's budget at the state level to make emergency loans to these nonprofit housing providers for immediate capital improvements. So things like $1 million to fix the roof finally. There's agreement that is something that should be funded and that it would benefit renters in those properties for sure. But what Maryland Legal Aid wanted was that the application for these emergency funds should include some indication that the ownership or management has consulted with the tenants who live at the property, meaning that tenants have an idea based on their experience in the property what like what emergency funds should be spent on, and it shouldn't be spent on things that tenants have no interest in. That that negotiation happened, and then the bill did not move out of committee. So there might be further conversation, but clearly this bill is about advocates on both the renter side and the development side or the ownership side agreeing that there is not enough money to preserve the existing affordable housing. Department of Housing Community Development in the Moore administration is very focused on using the amount of money that they have in the budget on creating new affordable housing, not preserving the existing housing. Perspective minded is great, but people still live in these properties. A lot of them are our clients. So that I'll wrap up there, and I'm sure there are questions. I will turn my screen off, and I'm happy to answer anything that I'm able to answer.
Thank you so much, Seth, for a really informative breakdown. I learned several things, so thank you so much. This is going to be available on YouTube for anyone who wants to go back, but we did get a question asking if the document you just shared is available anywhere online, or is that private Maryland Legal Aid information?
We've not published it, but I can give it to you all, and you can share it with your membership.
Okay,
There's
great.
no secrets in this document. Everything is
Okay.
on the record.
Okay, will do. So we can share that. And also, like I said, feel free to go back to YouTube if you want to hear Zephyr's explanation of a bill again. Did get some different questions. I saw a couple kind of about rent stabilization. I can address those afterwards. I want to focus on the ones that Zephyr can answer. There was a question about speeding tickets as a possible barrier to getting approved for an apartment. I think that you're talking more about how those aren't going to impact your ability to lease up. Something minor like a speeding ticket, correct?
Yeah, that's an interesting one that I admit was really not top of mind in the creation of this bill and its legislative process. If it were a speeding issue that became a criminal case and it did not result in a conviction, then it's not something to worry about in terms of criminal history used in screening. Now, it is true that that information will be available on Case Search, for instance. The real important thing in this fair chance bill is the ability to get, I think this is like one of the important things that, of course, as a lawyer, I'm really fixated on, I admit, is the ability to get all of the information that was used and then the opportunity under the law to rebut that information. So what people have to understand is that landlords get this information from somewhere else. They don't understand all the information. A lot of landlords, as you've probably noticed, as soon as they see anything, they shut you down and they deny you. That will not be a lawful practice. Your rebuttal information would address, for instance, like, well, that speeding issue entailed this, and there actually was no, like your record or your assumption about the records is inaccurate. I did not have any felony conviction for this. Maybe it was a misdemeanor, maybe it was nothing. So that, that's just something to keep in mind. And I should say too that organizations in the civil legal services arena, like Maryland Legal Aid, have not dealt with this at scale before. We didn't have this law before. So I will say that whenever you contact legal services of some type or any lawyer, bring up this issue, because we don't have systems to address it yet. We don't have like a standard interview question like, oh, have you been denied housing because of your criminal record or anything like that. Maybe we'll do that. That's something for us to have to figure out before October 1st. But if you're somebody who would be contacting Public Justice Center or Pro Bono Resource Center, Community Legal Services, Legal Aid, CASA, about, for instance, the threat of eviction, you may want to then also just bring up like you will potentially be facing the inability to get new housing after an eviction, or because of having to leave because of substandard conditions. because of this criminal record issue. So I just wanted to flag that for the future. It'll be very important for tenants to be part of the conversation about enforcement.
Yeah, definitely. Thank you for that. Did have a couple more questions for you, Zephyr, but I see our guest delegate Mary Lehman has joined us.
Great.
If maybe we could pivot for a few minutes, delegate. I don't know if you're on right now, but if you'd like, you can have the floor to talk about your legislation from this year, specifically the air conditioning bill.
Yeah, hi there. Can you hear me?
Yes, we can hear you. Thank you for
Hi,
joining
and
us.
I have actually been my camera doesn't seem to be working. I've been with you all the whole time. I've been with you since 7 o'clock and listening. I was at the grocery store and then arriving home and starting dinner, and I listened to my good friends and colleagues, Delegate Wilkins and Delegate Charkoudian, and I realized when you started talking to Zephyr, oh, they must not realize I'm here. So I just figured at some point I would make my way out of my kitchen up to my computer. And so, yeah, I don't want to, sort of disrupt the flow of the program, but I do want
thank you
to
for
tell
being
you a
with
little
us. Yeah.
bit about my air conditioning bill that I could not have passed without the just enormous sort of strategic and really fast action by both Zephyr and Vice Chair Charkoudian, with also a lot of help from Marlon Ampry, Delegate Ampry, who is brand new at chairing the housing subcommittee, I'm sorry, in economic matters. And I think Zephyr would agree, just did an amazing job. But long story short, the air conditioning bill I've worked on with Zephyr and Matt Hill and others for 3 years. This was the third year. And the third year was the charm, I'm happy to say. I have to tell you, I did not see it coming. I really thought that we were going to have to bring it back again in 2027, and really pleasantly surprised at what happened at the end. But the bill, what the bill does is say that as it was drafted, in rental apartments and buildings with 4 units or more, that air conditioning has to be provided in brand new rental housing, which I think most often it is these days. But what we were really trying to get at, and that's important, but what my real goal is to get older apartment buildings, and there are many of them in Prince George's County, built in the 50s and 60s, some earlier, 1940s, post-World War II, that have never had air conditioning. And of course, our summers are getting hotter and hotter with climate change. We had 36 heat-related deaths in the state of Maryland last year. That was a record number, and it was all over the state, including in Western Maryland, which is supposedly a little bit cooler. And so the bill passed the House last year, but was never voted on in the Senate. I did have a Senate cross-file this year in Chris West. And the reason why I thought it was going to run into trouble, and Senator West has been a great ally and advocate, but I had asked that JPR not move the bill first because I was afraid of what they might do with it in terms of amendments. And they went ahead and moved it, anyway. And so actually the bill got out of the House and went over to the Senate, but instead of taking up the House bill, they amended, I don't know, Zephyr might have to correct me. It doesn't matter. What happened at the end is that Senator West's bill is the one that went to the governor, and that's not important to me, who gets, whose name is on it. But long story short, where I thought it was going to get into trouble, and where Zephyr and Delegate Charkoudian, Vice Chair Charkoudian, were such a huge help, is that in Montgomery and Prince George's counties, we have had an air conditioning law on the books for a number of years. Now, it only applies in the summer months, from June to September, the hottest months. And it tells landlords when they have to turn that air conditioner on and at what temperature they have to set it, which is 80 degrees. A little bit warm, I know, but that's their standard. But it doesn't address, like we do, older apartments that don't have air conditioning. And so the way the bill gets at that is to say when an older building is substantially renovated, when its electrical panel is replaced, or when its heating system is is replaced or upgraded, that's when a landlord would have to add air conditioning. What the Senate did is to put preemption language in the bill to say that if this bill passes and becomes law, then no county, no local government, county or municipality, including Montgomery and Prince George's, which already have statutes, may change this state law that we're going to pass. And so they changed the number of units from 4 to 10, which was fine. We could live with that. But we didn't want them doing a preemption on the kinds of housing that the law could apply to in the future, or on that temperature, which probably in the next couple of years there will be an effort, I'm certain of it, to lower that 80-degree threshold because the summers are getting hotter and hotter. But Zephyr and Lorig really stepped up and said, no, we're going to make it clear to the Senate that we cannot tolerate your preemption language. We will not stand for it. We will kill the bill. We didn't say that overtly, but we had an agreement. We will kill this bill before we allow preemption language. And, it worked. Our strategy worked by saying yes to the 10 units rather than the 4. And I don't know, Zephyr, am I leaving anything out? Did we offer consensus on any other front?
I think we were willing to play ball on the definition of substantial,
Yeah. Yeah.
but it just didn't come up,
Yeah, it came up a couple times on the House floor. I don't know what happened in the Senate where one of the Republicans was questioning, what is this definition? Are you talking about when somebody just replaces a few outlets, or, what's the definition of a renovation? And Marlin answered it to the best of his ability. He said, no, it's more than a few outlets. It's I don't know if he said the whole electrical panel, but they, they kept distracting themselves, at least in the House. I don't know what they did over in the Senate, but I was sure that they were going to dig in on the preemption, and they gave in on it. And Zephyr, can you explain the other thing you did with the with existing housing,
Yeah.
where because I didn't think to address the temperature, standard and the calendar the way you realized. If we didn't have language around that, the standard in Montgomery and Prince George's was not going to apply, correct? If you can explain that.
Yeah. So the bill became a vehicle for some interests out there to preempt the local county laws, leaving Montgomery County and Prince George's County, as well as all the rest of the state, without a means to address all the properties that are not new construction and not newly renovated, and whether they would have air conditioning. And so, all of the properties that, for instance, already have air conditioning systems but are defective, don't meet that 80-degree Fahrenheit cooling standard, would have just had a pass. There wouldn't be a way to enforce the county laws because they'd be preempted by this new state bill. So it was incredibly important when the Senate Bill 12 got back over to the House, for the House to amend the Senate's work and remove that preemption language, and then also very specifically make it clear in the bill that a property that does have existing air conditioning systems as of last year, so 2025, would have to meet this new temperature standard, which is not new in Montgomery County, but the 80-degree Fahrenheit standard. So effective June 1st, properties that do have AC and the AC is not working will have to comply with the law, and tenants would be able to would have a much stronger chance of holding the landlord accountable for not having a working air conditioner.
Yeah, so thank you so much for the support from Zephyr and Legal Aid and Renters United and other housing groups over 3 years. The consistent support. I could not be happier or more pleased that we got this done this year, given when it was interesting. We were having these back and forth debates and sort of strategy sessions between the House and Senate and the conferees in April, the first week of April, and it was in the 90s already. And I don't think very many people try to argue with a straight face that our summers aren't getting hotter and that air conditioning really is a very serious public health issue and a quality of life issue. And so, Zephyr, just a million thanks for sticking with me on this. And we've been through a lot the last three legislative sessions, but we got it done. And I'm just so happy. Yes, I see that comment about intolerance and people with disabilities, elderly people, people with underlying health problems. That's true for even children with respiratory issues. But I will say, ironically, after, the legislation passed, it got some really good media attention. Politico wrote an article about it in their energy and environment news service. And I thought, Zephyr, I thought they did a really nice job with the article, very balanced, and quoted Zephyr and Senator West, myself, a public health expert at the University of Maryland. But right after session ended, I read that, and this isn't new news, back in March, I guess the couple members of the Montgomery County Council introduced, and the bill is still under consideration. I don't think it's gotten out of committee, but they actually introduced legislation to expand their air conditioning law in rental housing to include single family homes, which is huge. And I said to, I think Zephyr and a couple other people, if anybody can pull that off, it's Montgomery County. I can't imagine such a bill getting traction anywhere else, including in Prince George's, because of the influence that the realtors have. But kudos to Montgomery for thinking along those lines and looking to expand their law to single family homes.
Yeah, definitely. Thank you so much, Delegate Nguyen,
Absolutely. Thanks for having me.
Yeah, for sponsoring this and for giving us the overview. Couldn't agree with you more that, AC is not a luxury as maybe it's been treated in the past, but with the climate change going on, it's a safety issue for people. And it looks like the people in the chat agree with that. So thank you so much, and thank you to Zephyr
Thanks
as
for
well.
having me, and keep up your great work. Good night, everyone.
Thank you. Good night. Thank you so much, Delegate. Thank you for
Thank you.
joining us. We are coming close on time. Thank you, Zephyr, for letting us pivot a little bit. I did see a couple more questions for you, but I just wanted to say real quick, piggybacking off the AC conversation, Montgomery County Council has also proposed to, as the delegate mentioned, the AC law starts June 1st to September 30th, and that's when the temperatures have to be below 80 degrees. It has been proposed to move that start date to May 15th. As we see, it's not even May yet, and we've been getting a lot of hot temperatures. Today, not so much, but we've definitely got those 90-degree days. And some places their heat was actually still on. We've been getting a lot of complaints about that. So definitely the Renters Alliance is advocating for that. And we will keep you all updated on what happens with that. Okay, so let's see. I know a couple people logged off who had questions. Oh, I did see a question earlier about the water billing. And just to clarify, it doesn't require that all buildings install individual meters. It just requires that they have to be more transparent with how those bills are being calculated, correct?
That's right. It's actually quite rare for properties to be using submeters, and I've probably have heard of one besides the Grand through my work at Legal Aid, but I think it's probably like the future of water utility because water is becoming so expensive, and these submitters have some impact of reducing costs. But the problem, as you saw at the Grand, and as has been seen in other states that have passed legislation on this issue, because of hidden fees or junk fees in the process, tenants end up paying more, even though they now have a supposedly more accurate, individualized measurement of their water consumption. So we might see that there's more installations, like retrofitting units to use submeters. Mobile home parks also use these submetering. So this is one of those things, like, I'm surprised it passed in its first year this year. It's great that it did, and it will become more important in the future than it is today.
Understood. Okay. Then we had a question about air conditioning. Someone says that they have 20 tenants without air conditioning in downtown Silver Spring. Is June 1st when they can demand their HVAC to be fixed? Um, well, I could just start off by saying that if the HVAC is not working right now, you are totally within your rights to contact code enforcement. Um, if it's if it's if it's broke, like depending on how your building is, some buildings turn on the AC sooner than June 1st. So if you're they might not be required to turn it on, but if you're saying that there's like a repair issue that needs to be done, you can reach out to the Renters Alliance if you want to give us some more details on that, and we can help connect you to code if it is going to be code appropriate. Want to just make sure I'm reading your question correctly. Um, were there any other questions for Zephyr? Um, Tim, what did we see? I see a couple people are using the raise hand function. Please put your question, like type your questions into the chat due to our panelist format. We can't call on people. So if you could please put them in the chat. Um, if people are having individual issues with billing in their building, with repairs that aren't being done, broken appliances. Of course, you can always reach out to the Renters Alliance. Tim put our phone number and email in the chat, and we can connect you to the right resources. Um, Not seeing any more bill questions for you, Zephyr. Um, I'm seeing a couple rent stabilization questions, so I want to address that. So, Zephyr, thank you so much for that great overview. We love
Yeah.
having you on here. And we'll definitely have you back. Thank you so
Yeah.
much for the overview.
If I could just make one
Oh,
short
yeah,
comment.
yeah, please.
Because I did see, I think believe it's Mimi made a comment about the use of credit scores, and it is an issue, as Mimi said, that does affect a lot of women who are in abusive relationships or otherwise problematic relationships. This is such a common thing with voucher holders that, we had testimony on that voucher holder bill specifically about the use of credit scores when someone has been abused by their former partner. And has, that entails like credit problems, credit card bills, debts, all that kind of stuff. I think it's obviously more systemic than voucher holders. The voucher holder bill is a great starting point. Fair chance in housing on, criminal records is a great starting point. Delegate Stewart, as you know, is from Montgomery County. I'm certain he will bring back the bill on tenant screening and disclosure of tenant screening, et cetera. Like I said in the comments, this is an issue where legislators and many legislators are landlords. Okay, they might be small landlords, but many of them rent out properties. That's how they have income to then be a legislator for a quarter of the year. They do believe strongly, and I think at an intuition level, that credit scores tell them something very important about a person's ability to pay rent prospectively or to quote unquote be a good person. Same goes for adverse credit history as well as eviction history. Now, all these things can be up for debate, but I do want to just emphasize that when you have a debate, there needs to be information, good information. Right now, there is very little information about how credit scores impact people in Maryland specifically. And so folks in Montgomery County Renters Alliance I'm not even really suggesting it. I'm just saying like it's an idea. Talk to Delegate Stewart or others who represent you in the county about this issue, because it is kind of, it's just nonsensical. If you're a person who's ever applied for something and then had a credit check done and you didn't even know you're going to have a credit check and now your credit score is down, you can't repair your credit score by, for instance, paying off a debt, that will actually lower your credit score. None of this stuff makes sense. And yet it's treated as kind of like a holy sort of sanctified thing in the legislature. They just don't really know what's going on with tenant screening as a barrier to housing. So I just want to lay that out there.
Yeah,
Thank you
appreciate
guys
it.
for your time. I really appreciate it. And I hope this is very helpful.
Yes, thank you so much. I'm seeing a lot of comments in the chat, so people definitely appreciated the presentation and have thoughts on that. Unfortunately, we are running out of time, so we need to go over some of our usual resources. Thank you so much, Zephyr. We will definitely have you back again. Thank you. Have a good evening. Okay, really quickly, I just wanted to address, I saw several comments about rent stabilization and caps in the county and what was the MGA doing about rent control, rent stabilization. Just want to say that in Montgomery County, we do have rent stabilization. It doesn't apply to the independent municipalities of Rockville and Gaithersburg. It is a cap of 6% or inflation plus 3%. There were some comments from, I believe, some seniors at some senior buildings. If your building is new, I think we were at Kane Commons, which is a new building. Your building has to be at least 23 years old to be subject to the rent increase cap. So if your building was only built 2, 3 years ago, they have to be 23 years old before they're subject to that 6% cap. So I saw a comment earlier saying, does that mean they can charge whatever rent increase? Technically, yes, it does. You could be seeing double-digit rent increases. And if you are, please contact us, and we can also help you contact the Office of Rent Stabilization. There's no enforcement that is required if they're not under the rent stabilization law, but we still want to hear about it if you're being priced out by like a double-digit rent increase. And of course, we are advocating for the cities to include these rent stabilization protections as well. Okay,
Yeah,
super.
even at just real quick, Emily, so
Yeah.
sorry, even in a non-stabilized building and
Yes.
the increase that is excessive enough, whether you're a younger building in the county or in one of the municipalities, that if it's excessive enough, the landlord tenant office can review that. And I saw a question earlier about in our chat about Kane Commons
Yeah.
in Damascus. So also just if there's an affordable regime of any kind, like housing tax credit, or if you have to recertify in any way, there is some stabilization going on there. So if you're confused about whether you're under the county or a newer property like Kane Commons that does have affordable, almost entirely affordable units because it's part of a charity, please reach out because it's very confusing, and we are glad to help you parse through that.
Yes, please reach out. Tim put our contact information in the chat. I see some people saying, unfortunately, they missed certain parts of tonight's town hall. You can find this on YouTube later. Just really quickly want to say, if you're having issues with maintenance problems, you do have an outlet, which is code enforcement through the county. First, you should try to talk to your manager about whatever repairs aren't being done, maintenance problems, condition issues, pest issues. If management is not dealing with it in a reasonable amount of time or is not completely fixing it, you can escalate by contacting Montgomery County Code Enforcement. You can call 311 or you can also Google them. You can also reach out to us if you need help getting in touch with them. Similarly, if you're having issues with the landlord, if you're having issues with your lease, if those kinds of issues are going to go to the Office of Landlord Tenant Affairs. You can call 311 not to make a complaint, but you can talk to them over the phone to actually file the complaint. You will have to go online. Again, you can just Google Montgomery County Office of Landlord Tenant Affairs, or you can email us at info@rentersalliance.org, and we will send you the link. And as Tim put in the chat earlier, if you are facing eviction, there is the Access to Counsel and Evictions program through the state of Maryland, where you may qualify for a free attorney if you are a low-income tenant facing eviction. If you want to hear more about any of that, you can contact the Renters Alliance, info@rentersalliance.org, or give us a call, 888-668-7717. Just want to thank you all so much for tuning in tonight, for all the great questions and comments. It is a conversation to be continued. Please reach out to us, and I want to thank my colleagues, Waho and Tim Wong, for helping me hold down the fort tonight. It is 8:30, so thank you all for joining. Please join us on our next town hall. It will be Wednesday, May 13th. The topic is to be determined, but you will get a newsletter with us updating you on what we will be discussing in a few weeks. Thank you all so much. Hope you have a great evening and see you all in a few weeks.